1.
The clerk will open the court.
Oyez, oyez, oyez. The Honorable Court of Criminal Appeals is now in session.
We're ready to hear argument in cause number PD-0478-20, Robert F. Hallman versus the state of Texas.
Good morning, Your Honor. This is Shelby White for the state. I'd like to begin with laying the foundation for what this case is and why we're really here today. I think that everyone agrees the statements made by Kim in her family violence factor were not disclosed prior to guilt innocence, even though the disclosure was inadvertent. Everyone agrees that the information would have been relevant. I think where everyone disagrees is whether or not Hallman actually would have been harmed by this non-disclosure. And so in light of this court's recent opinion in Watkins, which postdates our briefing in this case, Watkins has taken 3914 out of the Brady scheme and out of that traditional Brady analysis. And so the errors presented now are not under a materiality standard in Brady, but they are under a 442B harm analysis, or in this case, they would be under an abuse of discretion for a denial of a motion for mistrial. And so in that case, our issues presented have changed slightly. So I'd like to just go over those again. First, it would now be, did the Court of Appeals err in applying a de novo standard of review to the trial court's denial of a motion for mistrial rather than abuse of discretion? And then what were our issues 2 and 3, I think now interplay quite a bit more than they used to. But second, under the appropriate standard of review, was the failure to disclose the handwritten witness statements so harmful that the case must be redone? And third, in light of the entire body of evidence, did the Court of Appeals err in concluding that the trial court was outside the zone of reasonable disagreement in concluding that the appellant's inability to impeach the witness, Kim, regarding her a distant extraneous offense with her own handwritten statement did not warrant a mistrial?
Counsel,
So
why don't we just remand the case for statutory harm analysis in light of Watkins?
well, and I think that that goes to what, if you look at Watkins in the state's letter brief that they submitted afterwards, and even if you look at the harm analysis, or in this case, denial of a motion for mistrial, what most courts have been saying is that, and what the state said in that letter brief was that it's different roads that get to the same result. And so I think that even if we are doing a harm analysis, the body of evidence is still the same. The issues that we were looking at are still the same, and the Court of Appeals still erred in finding the evidence that the non-disclosed evidence warranted a mistrial in this case. And so I think that it would be appropriate for this court to render in this case, looking at either the harm analysis or denial of a motion for mistrial, because it is still the same. We're still looking at the same evidence, and this court is still able to make a decision as to that. On to my first point of error, which is whether or not the trial court erred in applying a de novo standard review to denial of a motion for mistrial. And in Hawkins, coming out of this court, the harm analysis is employed only when there is an error, and ordinarily error occurs only when the trial court makes a mistake. However, when the only mistake was the trial court's denial of a motion for mistrial, then the proper issue is whether the refusal to grant a mistrial was an abuse of discretion. So when we compare that to Trial Rule 44.2b, saying that any error that says any error that does not affect substantial rights must be disregarded, the case law is consistent that those are that the denial of a motion for mistrial involves the same considerations as a 44.2b harm analysis. And therefore, now that we're under the abuse of discretion standard, the reviewing court has to uphold the trial court's ruling if it's within the zone of reasonable disagreement. And previously, this case had been reviewed under the Bagley factors, which looked at the failure to disclose, whether or not the evidence was favorable, and whether or not the evidence is material. And in the Court of Appeals applied a de novo standard of review to materiality. And now that we are under the Mosley factors, we're under a simple abuse of discretion standard for denial of motion for mistrial. The Mosley factors look at severity of misconduct, measures adopted to cure the misconduct, which is not a relevant factor in our case. And then third, the certainty of conviction absent the misconduct. And so in considering those factors, we look at our second and third points that we presented for review, looking at all the evidence in light of the Mosley factors and comparing it to the non-disclosed evidence in this case. And so when we're looking at first the prejudice factor, I think the prejudice Mosley factor, there are three factors that show that Hallman was not prejudiced by the non-disclosure. First, we can compare the impeachment that did occur versus the impeachment that would have occurred with the with Kim's handwritten witness statement. And basically these two pieces of evidence are virtually the same. We're looking at, again, two roads that get to the same destination. We're still impeaching her on the same issue of whether or not she lied when she said that she told the police officer that she suspected her children were being sexually abused. She's impeached version 1 through the police officer getting up and testifying saying, she never told me that. Or she could have been potentially impeached through version 2, which was if they had had her handwritten statement, they could have said, you know, you never mentioned this in your handwritten statement. Isn't it true you never said that? And normally, obviously, when we're looking at Brady evidence, or when we're looking at impeachment evidence, we're comparing exculpatory evidence, exculpatory non-disclosed evidence against and comparing it to the entire weight of the inculpatory evidence that was admitted at trial. But here, part of the reason I think this analysis is so different, and part of the reason I think that rendering is appropriate, is because we are comparing two pieces of the same, two pieces of evidence that get to the same destination, that get to the same impeachment. And this dovetails with case law that we're talking about, the erroneous exclusion of evidence, where it says that the erroneous exclusion is harmless if the evidence is cumulative of other evidence, or if the nature of the evidence is established through other means. The second factor under the prejudice Mosley factor is that if you actually look at the entirety of the record concerning Kim's testimony, I think it's pretty clear that when she says, I told the police officer I suspected my children were being sexually abused, that was not a statement that had much credibility to begin with. It was not a statement that the jury put a lot of weight behind, because she starts out on direct and she talks about all the suspicious instances where Hallman is doing things that seem a bit creepy and to make it seem that her children are being sexually abused, and how she doesn't do anything about it. And then we look at, she talks extensively about the actual domestic violence incident that forms the basis of the handwritten statement in the police officer's report. And she never mentions on direct, never mentions that she told the police officer anything. And then during cross-examination, the defense specifically asked her, did you tell the police about your suspicions? And at first she said no, and that's volume 11, page 195. She says, I didn't tell a police officer anything. And then a few pages later, page 200, the defense is kind of hammering her about all these specific instances of suspicious conduct by Hallman. And they said, well, if you didn't tell the police about it, why didn't you at least confront Hallman about what he was doing? And at that point she says, oh wait, I did actually tell the police about it. And so I think that if you look at the entirety of the record and you look at the context of that statement, it was pretty clear that it was not a credible statement to begin with, and it was made more to save face than to be taken for the truth of the matter. And you can also compare that to the fact that Amy, the daughter who allegedly, if you look at the police officer's report and what Kim says, she says that I told the police officer my daughter was being sexually abused, and then the police officer went and talked to my daughter about it. And so Amy gets up on the stand and she never mentions that at the time of the domestic violence incident, a police officer confronted her or asked her about whether or not she was sexually abused. So I think that already undercuts Kim's testimony. And then you have the fact that the police officer does come in at trial and directly impeach her, and he says, A, she never told me that. B, if she had told me that, I would have put it in my police officer report. And C, if she had told me that, I never would have confronted the daughter directly and asked her about that, because it's against my officer training. And then I think the last factor that goes to prejudice is that the defense does not rely on or overly emphasize the impeachment that they did have. And this undercuts the theory that had they had version 2 of the impeachment with Kim's handwritten statement, it would have totally changed their cross-examination of Kim, or totally changed the way they presented their defense. Because again, we have impeachment version 1 that gets us to the same result, and they didn't do anything different with it. And also you can look at the fact that at the hearing on the non-disclosure, which is in volume 18 at the beginning of the volume, the court actually gave the defense the opportunity to cross-examine Kim and said, you know, you can bring her back in and show on the record what her impeachment would have been with the handwritten statement. And the defense never takes that opportunity. So we don't really know what the impeachment would have been or how different it would have been. And I think if you look at the handwritten statement versus the police officer's testimony, it shows that the result would have been the same and the jury's outcome would have been the same. And next, I think we want to look at the certainty of the conviction absent this evidence and the entire body of evidence. And I think where the Court of Appeals errs, and again, why this warrants more than just a mere remand and why it warrants a rendering, is because the Court of Appeals overemphasizes the importance of Kim's testimony. Kim's testimony is not the central issue at trial. She is not the main witness. We have actually 2 adult daughters who are testifying at trial about the sexual abuse that occurred while they were teenagers. So they're not young children. We're not dealing with a lack of memory issue, and we're not dealing with children who don't necessarily understand what happened to them or why it happened to them. We actually have 2 adult daughters that testify in great detail about when the sexual abuse occurred, how it occurred, what exactly happened, where they were, where they lived. And so this idea that mom could get up on the stand and have her credibility dinged just a little bit, and that somehow would have undercut the entirety of the case, I don't think that that rings true. And I think that the Court of Appeals erred in overemphasizing the importance of Kim's testimony. And especially when we compare it with, keeping in mind that this is impeachment evidence, when we compare it with other cases where we have held that impeachment evidence was sufficient to undercut an entire case. For example, this court in Ex parte Richardson, we had a sole eyewitness to a murder, and she gets up and testifies, the defendant is found guilty, and then later it comes out that 6 different police officers, including one police officer who specifically kept a journal detailing all the times that this witness had lied while she was in police protective custody, and how the police officers were basically concerned that she was trying to make them look bad. And so this police officer had a journal detailing all the specific instances where this witness had lied. And then we had 6 other police officers willing to testify that, yeah, she's definitely a known liar. That's the kind of impeachment evidence we're looking at that really, really undercuts the guilt of the defendant. It is not minor impeachment on mom that doesn't actually undercut whether or not sexual abuse occurs. It undercuts whether or not she told someone else about the sexual abuse. And so it doesn't actually even ultimately get to the heart of the case. And again, even if the jury completely discounts Kim's testimony, we still have the 2 adult daughters and their testimony still stands. And I see that I have a little bit more time left. I didn't know if there's any other questions from the court. If not, for those reasons and the additional reasons that are outlined in our brief, we would ask the court reverse the Court of Appeals opinion and render a decision that the trial court did not abuse its discretion in denying Hallman's motion for mistrial.
Thank you, counsel.
Thank you.
Good morning. Can y'all hear me?
How was the beach?
I didn't know. It was great.
Counsel, I don't want to throw you off, but I do want to remind you that this is a courtroom, even though it's remote, and swimsuits are not appropriate in a courtroom.
That's not a swimsuit, but I'm sorry. I didn't
Okay.
have no idea that when they said, I had no idea it was going to show up like that. So
That's fine. That's fine. I don't want to throw you off. So I appreciate the creativity anyway.
She gets on me about that all the time.
Okay, well, good morning. I appreciate the opportunity to speak to the court. It just would be my luck that I would have that faux pas, first of all. And second of all, that my first opportunity to speak to this court in my whole career, it winds up on a screen rather than in person, but I'll take it. Thank you for the time. The first issue that I'm have a question about is from the state's argument. I am not sure whether they've conceded materiality and just went straight to a harm analysis or not. So perhaps that can be addressed on rebuttal. In that regard, I don't know which one to address more. I think materiality was conceded to some point, and so I can go straight to harm. But to answer a question that was posed earlier, the reason why remand in light of Watkins, in my opinion, is not the appropriate response to do a harm analysis, because the Court of Appeals has in essence already conducted a harm analysis in making the materiality finding under the old Brady standard. Clearly, if it was material under what the courts prior to Watkins were discerning as Brady, then it's harmful and requires.
is the claim at issue though, in this case, a constitutional due process claim, or is it a violation of Article 3914?
Statutory 39.14. Yes. So, but I still think it covers it. When you make the Brady materiality determination, that it basically affected the verdict in the case, or has a high probability that it did, a reasonable probability that it did, how does that not meet the substantial rights violation of our statutory law harm analysis? I think
Did this case just come down to a he said, she said? Was there any physical evidence, expert testimony of the sexual assaults occurring?
It was he said, she said regarding no DNA, no physical evidence, things of that nature. They did have some experts regarding child testimony and things of that nature, outcries, but nothing, no physical direct fact, if that answers the question.
Thank you.
So I believe the Brady materiality finding, although now it's not going to be correct, inherent in that has been a finding of harm under the statutory violation issue. The first point, the first point in the state argued is the de novo versus an abuse of discretion in regards to the denial of the mistrial. And that the court erred in doing a de novo review. In this particular case, the court didn't. They did it on an abuse of discretion, which is the proper standard to review on a denial of a motion for mistrial. However, there's two caveats to that that's very important for the court to be aware of. And that is, first, the reason why they did somewhat of a de novo review was because the old Brady materiality determination required that to some extent, being law and fact. And two, and of most importance, is the whole purpose of the abuse of discretion standard in review is because of the assumption that the trial court is in a better position to assess credibility of witnesses, to assess the demeanor of witnesses, the character of witnesses, how strong their testimony comes out on a human level. And so the trial court should be given a lot of discretion or deferment because they actually saw that, live, not on a cold record as we all do it in the appellate world. However, that is completely negated on the facts of this case. The trial judge that sat during the entirety of the guilt innocence phase of this case was not the judge that ruled on the motion for a mistrial based on the Brady violation. And so there's the deference, and going all the way back to Guzman, when it first came out, how important that deference is on an abuse of discretion standard is inapplicable because the judge that made the ruling was not in a better position than the court on a cold record to make that determination because she saw none of the testimony. And in fact, the defense counsel at trial requested, bring the visiting judge back who heard the evidence and let him just rule on this. He's available. He can be here. He's the one that should rule on this because he saw the evidence. And yet that was not done. That request was denied, and the judge made a ruling that is not entitled to deference given the facts of this case.
Ms. Mullen, was the discovery error, was that preserved other than in the motion for new trial?
Preserved as far as,
I mean, was there an objection, sort of a trial level objection, other than sort of a motion for new trial? Was there sort of an objection to something that wasn't a motion for new trial, if you will?
Yes. There was a lot of objections once it came to light at the punishment phase that evidence had not been disclosed. So yes, there was, the 3914 starts the beginning of the perfection of that, I guess, error. The proper request was made. And then as soon as it came to light, like I said, at punishment, that's our first opportunity that the defense counsel had to object that they had not had it disclosed.
Thanks.
Ground two, I think, on the state's issue is moot, given Watkins, and because might have tipped the scales is not really an issue anymore. And if the court found that it might have tipped the scales, then obviously it would have the Watkins level of a logical connection to a fact of consequence. And on ground 3, I guess that's where we kind of get into the, if it's either harmless or material. I think materiality is clear, and harm is also clear, in my personal opinion. The fact that this was material, basically 3 reasons I'd like to focus the court on to consider. And one is undisclosed evidence had a logical connection to the facts of consequence simply by virtue of the fact that at the guilt innocence, the state was the one that offered the extraneous offense in evidence in front of the jury, and the reports that they did not disclose referenced that exact offense that they offered the testimony in. So obviously it was relevant because the state actually proffered that extraneous offense in the case. So obviously it was relevant and probative and important for them to put it in, yet denying the defense opportunity to review all the documents. Second is the impeachment value, which the state in their argument tries to add or states that it's of minimal importance. I would tell the court that actually the mother in this case and her credibility was the crux of the defensive theory in the
I'm
case.
sorry, but she's the crux. But she's not the complainant or the complainants.
Correct.
So if she's the crux, what about the actual victims in this case?
She's the crux of the defensive theory in the case because the whole defensive theory was that she had manipulated the 2 girls. There was a number of children, but the 2 girls in this case to make outcries of sexual abuse in order to obtain an upper hand and, more importantly, custody of the girls during the course of the divorce. And it all comes back to her actually getting them to say these things as a defensive theory in the case. There was a lot of evidence that showed that whenever the younger girl would want to go with the father and live with him, and she would be infuriated by that. And then when the divorce issue came up, when they really were actually going to separate for the final time, that's when, and the daughter once again went with the dad, that's when the other daughter who remained with her, we'll call her the older daughter, supposedly made this outcry of sexual abuse to the mom, which was supposedly have been going on for years and years previous to that time. The timing of it is very important because mom's credibility, her character, her truthfulness, her ability to be manipulative obviously would be very important to the defensive theory of the case. Whether you don't like the theory or not, that was the defensive theory. And just to be able to show that she was being manipulative, even in her testimony to the jury, it was very important to the defensive theory. It wasn't minimized. It wasn't minimal at all in this case. And the Court of Appeals correctly found that from reading the entirety of the record. The timing and the time frame is very important for the court to consider, as the Court of Appeals did. And that is, there was no outcry or no allegation of any kind of sexual abuse whatsoever until the divorce, the final separation, and then the daughter left and wanted to go live with dad. 2 days later, supposedly the older daughter outcried to the mom of sexual abuse. She called the police, daughters returned to mom. So that goes for a year. The case is pending. Nothing's happening, and the other daughter makes zero outcry during that year period of time when she's back home with mom. Then we get right at the crux of trial, and at the crux of trial is when the older daughter begins to not want to testify. She's refusing to testify. When the mom tells the younger daughter that, according to the mom's testimony, that's when suddenly we get another outcry from the younger daughter. And obviously credibility was an issue for the jury to some regard, we can tell, in the fact that the continuous sexual abuse count, Mr. Hallman was acquitted on. That's the only count that had the older daughter's outcry or as a victim in the case. And so clearly there was some lack of belief regarding her testimony because the jury acquitted him regarding the only count that occurred concerning her.
Did the jury send out any notes during the trial that are in the record?
I'm sorry, say that
Did the
again.
did the jury send out any notes during the trial that might be in the record?
I honestly don't remember. I'm
Okay.
sorry.
That's okay. I can check.
If they did, I would have put that in my brief. So, but I
Okay.
don't. Minute.
May I ask you, Ms. Mullen, a question about that family violence report?
Yes.
It seems, looking at it, that it was asking about that actual incident that was being investigated on that day. Is there something you can point to on the report itself or the questionnaire or however it was presented to the mother that would suggest that she should be answering questions about something other than that acute alleged offense of family violence?
Okay, if I understand you correctly, you're asking, would there be any questions that would have been asked of her concerning sexual abuse?
Well, I know that the report has these little checkoff boxes, sexual assault, this, that, or the other, but it seems like that report is geared towards that specific event and not other things. That's what I'm asking about.
Oh, well, I mean, if had we had the report, I mean, that was part of the stuff that was not disclosed. Had we had it, I mean, what we know with the family violence packet is what they're looking at is the entire course of conduct. So the police officers are trained to ask all of these questions, not in regards to this acute incident, which could have been developed, but as to the whole history, because that's actually how they calibrate the degree of level of risk to harm in those check mark boxes. That's really a calibrated form to where the cops are trained and the courts look at the risk assessment in a case, depending on the longevity of the conduct and the type of conduct. So yes, in short form, yes, that would have been a specific question that's asked because you're looking for any other combination of events that would go into a risk factor from a domestic violence situation. I hope I made.
Ms. Mullen, I have a question.
Yes.
This 13-page document or packet that was not given to the defense until the second day of punishment, tell us how this could have been used during the guilt innocence phase if the defendant the defense attorney had this information before trial.
Absolutely. Well, the first thing is the witness's statement, and what's important to consider is the mom who, like I said, was the point of the defense of manipulating the kids. When she's pressured on the fact that she's now saying this happened for all this time and she never reported it, her response is, oh, yes, I did report it. I reported it during the assault. And not only does she say that, she goes into very explicit detail on what the report was, what she said, very, very explicit. Now that point, if true, then negates the defensive theory that the sexual assault allegations were part of the divorce, I want custody battle, because it would have predated. So for somebody to be able to lie about that so explicitly and so detailed fashion about making this statement during the assault case would show a character of manipulation, would show a character that would help the defense immensely in their arguments there. So when you've got, I call it liquid gold, when you've got a witness's own handwritten statement that you can use to impeach them when they come out with such an untruth, you can absolutely show a lie under oath. You bring it up to her, you show it to her in her own handwriting, very different inquiry, any trial attorney knows, than if you're just talking about what a third party, an officer, put in an offense report. Also, had they had the whole packet, that packet was very important in that there were specific questions asked about any type of sexual abuse. No. Thirdly, and really importantly, is the state then used the lack of turning over those documents in order to show that the officer maybe didn't put that in the decor report. Remember, the detective testified because obviously this impeachment was so important, the defense wanted to call the officer to prove she made no mention of that predating the divorce situation. And the state's cross-examination was, well, this is just a decor. you don't put everything in the decor. She could have clearly told you about that and you don't remember. This was a long time ago, totally dispelling the impeachment value of it. And the actual documents that were non-disclosed would have absolutely completely rescinded that, because the officer's probable cause affidavit that he wrote and swore out under oath mentions nothing to do with sexual abuse and was never disclosed. The actual handwritten statement of the witness would have certainly refreshed the officer's memory. So it would have disclosed all of that, trying to shore up the witness's credibility regarding that impeachment value. So different ways, it would have been a wholly different scenario and she would not have gotten away with that testimony whatsoever. And with the state's cross-examination of the police officer and redirect of her, it negated the impeachment value that we had at trial.
And also, do we know when the state got this evidence? Did they have it long before trial, or do we know that?
They had a long time before trial. They had it since since the time of the offense, which was going to be 2014. So that violence packet, all of that was in the state's files from way before, albeit misdemeanor files, not the felony file. We don't know when that actually came into their hands, but it was clearly at the DA's office in general and in the misdemeanor assault family violence file. I don't know if y'all have any other questions. I think that covers everything. I can't see my time, so I don't know how much time's left, but if you don't have any.
You have almost 2 minutes left.
Okay, well, if there's no other questions from the court, I would respectfully request that I feel like the case should be improvidently granted and that a harm analysis has been made. Watkins has now determined materiality in this case. And because the lower court correctly found harm, that finding should stand.
Thank you, counsel.
Sorry, let me get my things organized. Good morning. First, I want to talk about, I think Counsel Ms. Mullen says that we conceded materiality. No, that's an incorrect statement of what we conceded. We have never disputed that the evidence was relevant, but materiality requires the court to find that there was a reasonable probability that the outcome would have been different, which plays into the same analysis you would do under substantial harm or abuse of discretion for denial of a motion for mistrial. We've never conceded that this would have changed the outcome of the trial. Second, I want to go into discussion of the abuse of discretion and the Brady materiality standard, which this is where the trial court erred that I think that is not so relevant anymore, is that under the Brady materiality standard, you would apply a de novo standard of review to the materiality factor, which is what the Court of Appeals did. But now that we are under simply a motion for mistrial, abuse of discretion, there is no de novo review. It is simply, did the trial court abuse its discretion in denying the motion for mistrial? And to the extent that opposing counsel talked about the appropriateness of the ruling by the visiting judge versus by the trial judge, we did brief that in the lower court of the Court of Appeals. The Court of Appeals did not write on that. But first, I think that it's a slippery slope to say that there are instances where the elected judge is not allowed to rule on cases that appear before her in her court. And so this idea that she, even though she did not sit during guilt innocence, she did sit during punishment, and that suddenly she's not allowed to rule on issues that come before her, I don't think is an appropriate standard. And second, I think we also need to keep in mind that she did actually sit, this trial pended for 2 years, and there were extensive discovery motions prior to that. So this idea that she wasn't familiar with the nature of the case or she didn't know what was going on is completely wrong. She was very familiar with the facts of the case, with the witnesses of the case, and it was totally appropriate for her to rule during punishment as to something that had happened during guilt innocence, even though she didn't sit and preside over that phase directly. And then third, that issue was not actually preserved. If you are requesting that a visiting judge come back and sit for a different portion of trial, you need to show in the record that that visiting judge was actually authorized by an order to be able to sit on that particular day or to sit and preside over that particular portion of the trial. And there is nothing in the record that indicated that the visiting judge was available to sit that day and that he was authorized to sit that day. And so that issue was not actually properly preserved for the Court of Appeals to.
How much time, how much time was there between the visiting judge's portion and the sitting judge's portion?
I'm not 100% sure, but I think it was a day or two.
Oh, okay.
I don't think that there was an extensive period of time between the guilt and the punishment phase, but don't quote me on that. The third thing I want to look at is, this is something that was discussed in the Court of Appeals and then it was discussed by opposing counsel here, was this idea that because they acquitted Hallman as to the continuous sexual assault count, that therefore the jury had some issues about his credibility. If you look in the record, there actually are 4 jury notes that come out. 3 of them are about the timeline, and the 4th one asks for what the definition of continuous is. And we put this in a footnote in the brief, I believe, but Rita is the only allegations of sexual abuse as to Rita are under the continuous, and the continuous is continuous sexual abuse of Amy and Rita. And then as to Amy, there are 6 individual counts, and the jury finds all 6 individual counts and sentences to life, and it gives them the maximum sentence on each one. And so this idea that the jury had some dispute about what happened or whether or not these children were sexually abused, I don't think is really accurate. But I think that there is some evidence that they were confused about what continuous meant. And so I don't think that the Court of Appeals can make the leap and say that because you found no as to continuous, therefore knocking Rita out of the game, that they didn't think any of her specific allegations of sexual abuse were necessarily false. I don't think that you can say that because there's only an allegation of continuous as to Rita. And so it's very possible and likely that the jury did find that the specific instances she alleged were true and she was telling the truth. They just either didn't understand what continuous was or they didn't necessarily follow or believe the timeline as to when those incidents happened. The last thing I want to talk about is the police officer's report. I think that I don't think that it rings true, this idea that we would have had a totally different impeachment had we been able to use the handwritten the handwritten witness statement versus using the police officer's report. And opposing counsel talks about how the state cross-examined the police officer and tried to leave this impression with the jury that he didn't remember what happened and that he could have not written it down. That actually is completely belied by the actual contents of the record. That's volume 14, pages 207 through 212. There's never an impression left with the jury that the police officer failed to include a report of sexual abuse in his offense report. He actually consistently testifies that if anyone had said that to him, he would have included it in his report. And then he also testifies, as I mentioned earlier, if things had happened the way that Kim said they happened, he wouldn't have done the things that she said they did. That, in other words, if he had received a report of sexual abuse from Kim, he never would have gone and spoken to the daughter directly about allegations of sexual abuse. And so I think there was never an impression left with the jury that he had received a report of sexual abuse and just didn't include it in his offense report. And just to circle back to the very beginning, I know we've talked about reverse and render, and because, as we talked about, the materiality standard plays a little bit again into the harm analysis and into, in our case, the abuse of discretion analysis. And that's why I think rendering is appropriate in this case, because even though the Court of Appeals made a materiality analysis, the ultimate result is still wrong, and the ultimate result would still be wrong under the harm analysis. It's when we look at what happened here, if this court applies the harm analysis, we can see that the non-disclosed handwritten evidence was not enough to rise to the level of warranting a mistrial. It was not enough to rise to the level of meeting a materiality standard under Brady. They're both the same result. And so I think that the Court of Appeals erred, and whether we put it under a harm analysis or whether we put it under the Brady materiality analysis, it's still an error. And so I think the reversing and rendering would be appropriate in this case.
Shouldn't we give them the chance to do it first? Why don't we give them a chance to fix it?
And I see I'm almost out of time, if I could go ahead and answer your question, Judge Newell. And like I said, I think that normally, I understand your reasoning about wanting to give them a chance to do again, but because the standards of review because the analysis is looking at the same pieces of evidence, I think we're talking about 3 different roads to reach the same result, or kind of comparing apples to apples, basically, but it wouldn't have changed the outcome of the trial. And the Court of Appeals has already found that would have changed the outcome of the trial, and that's the wrong decision. And so I don't know that giving them a chance to redo it under the harm analysis that they would reach a different decision. And so we would just be back here again saying the Court of Appeals erred in finding that it wasn't sufficient to warrant a mistrial, though that didn't mean that it was a substantial harm. And so I think kind of for the interest of saving time and for the interest of correcting the error that actually occurred, regardless of which standard we put it under, rendering would be appropriate.
I have one more question for you. Could I ask one more question? I know you're out of time, but
I'm happy to.
Judge Beach was the elected judge, and she presided over the punishment, correct?
Yes, Your Honor.
But not the guilt innocence.
Correct.
Correct.
Yes.
Okay. So, and you said earlier that she was very familiar with the facts of the case. How would she be very familiar with the facts of the case if she didn't preside over guilt innocence?
And as I mentioned, this case was actually pending for over 2 years, and there were extensive discovery motions prior to trial. And also, we approached the eve of trial before Amy made her outcry, and we ended up basically re-indicting everything. And so we had made it all the way up to the eve of trial under Judge Beach being prepared to preside over guilt innocence the first time. And so even though she didn't actually preside over guilt innocence, I do think that she was very familiar with the facts of the case and what were going to be the issues in the case. And then if you look at the hearing, what she does is she compares the two pieces of evidence. She looks at the handwritten statement and she looks at the police officer report, and she says, these are so similar, I don't see how it could have been material. If you've got two pieces of evidence that basically reach the same result, get you to the same end, I don't see how it could have changed the outcome of the trial. And we do believe that that is the correct, the trial court was correct in that ruling.
Thank you,
Okay,
counsel.
thank you.
Thank you.
Time is up. The case is submitted and the court will stand in recess.
Oh yay, oh yay, oh yay. The Honorable Court of Criminal Appeals now stands recessed, subject to the call of the presiding judge.